Welcome to TST Broadcasting, bringing you news and views of owners and industry professionals. This is Shep Altschuler, publisher of TimeSharing Today. There have been some recent developments into the long drawn-out investigation into alleged wrongdoings by the developers of New York's Manhattan Club. Owners there have been caught in limbo for over 2 years, and it's important for the industry and owners of other timeshares to understand the complexities of this investigation and to the court's actions. To help us understand the issues, I am once again being joined by attorney Doug Wasser with the law firm Wasser Russ and by Jeff Weir, chief correspondent at Redweek. Hi, Doug and Jeff. Welcome to the broadcast.
Thank you.
Hello, Shep.
The situation with the Manhattan Club is not new, and the litigation that's been going on is not new. The impact on the owners has been taking an extremely long time, and it's been rather agonizing. So, Doug, talk about a little bit about the background of this conflict that's going on with the Manhattan Club, prior to us getting into the most recent court ruling.
Great. Okay, thank you, Shep. I think this is the third podcast that you're doing on the Manhattan Club. The background is Manhattan Club is a project, a timeshare project on the west side of Manhattan. Consists of, 286 units. And most of the 286 rooms, most of them divided up into weekly units. So 286 times 52 weeks in a year, somewhere in the neighborhood of 14,700 units. Some of those units are further broken down, 3 days 1 year, 4 days another. So that's the essence of that community, that development. Starting around 2004, 2005, owners began to realize that their annual dues, which were promised to them never to exceed several $100s in amount, started to climb up there, so that today dues and assessments for a weekly unit are a couple $1,000s. And that wasn't the only complaint. Having paid those annual dues of a couple $1,000s, Manhattan Club owners could not book a room and try as hard as they could. They could never book a room. And the dues were, the annual assessments were use them or lose them, so that they had no credit for not being able to book a room in the development. There were always commitments. Every time Manhattan Club owners tried to book a room, they were always sold out. But apparently you could always get a room by going on the website, the travel websites, hotel.com, Expedia. As long as you were able to pay retail price for those hotel rooms, you were able to book a room. So there was availability on the retail sites, but not to Manhattan Club owners in general. They've complained, the Manhattan Club owners complained to the New York Attorney General, and 2 years ago, the Attorney General commenced, they had an investigation ongoing, and 2 years ago, in July, August of 2014, the Attorney General was able to go to court and to secure an injunction that accomplished two things. First, it stopped the sale of Manhattan Club timeshare units. And secondly, it froze a whole bunch of Manhattan Club and sponsor bank accounts. The sponsor being Ian Bruce Eichner and various of his partners. And the Attorney General thereafter began to commence and conduct his investigation at the Manhattan Club. And that's what's been going on for the last 2 years.
Yeah, before we get into the update, Jeff, give us a brief summary of what the impact has been on the owners that you've been in touch with over this long, drawn-out period.
Well, Shep, thanks for having me. I do contact owners frequently, get contacted in return, and for those who are paying close attention to this court case has gone on so long that it's agonizing for the average owner, because they have 2 or 3 very, very real questions that are not being addressed by anybody. One is how to continue using their timeshare, given all the turmoil around the club. The second is whether they should keep paying maintenance fees of a couple of $1,000s a year. And there's a raging debate amongst owners about whether they should pay fees to maintain some good standing and hope that down the road they'll be able to sell their timeshare or maybe use it again. At the same time, there are other owners who are so angry at what has happened over the last 10 years in particular at the club that they are flatly refusing to pay fees and that guarantees two things. They will be denied access to the club, officially by the club. And secondly, they'll start receiving threatening letters from the club about collections of their fees. And a lot of timeshare owners are nervous about things like having their credit ruined, so they don't like that happening. However, because of the court order that's been in play for 2 years now, the Manhattan Club has no legal authority to foreclose on any owner who may not be up to date on their fees. And the whole process of what to do with their timeshare is totally stuck in a limbo, a legal limbo that has been dragging on for some time because of a lot of legal maneuvering from the developer Manhattan Club side to just drag on the proceedings. So the owners are the unintended triplicate victims of this, where they felt like they were victimized initially by their inability to get reservations and having to pay higher fees. Then they discovered that the club may be doing some activity that amounts to potentially civil fraud and maybe even criminal fraud. And now they're stuck in this long, slow dance of a legal machination that Doug can elaborate on, thoroughly. But it's beyond the pale, beyond the experience of most owners. So on a day-to-day basis, owners are frustrated, angry, and they're venting.
I guess the last podcast that we did, Doug, and I said this seems to be, caught up in some bureaucratic quagmire, and you said, no, this is how the wheels of justice turns, and now we have this recent court ruling to show, in fact, that the wheels of justice are turning. So maybe talk about that recent ruling. When was it? And maybe provide some detail about what it's all about.
Okay, well, there actually have been two rulings, one in the end of May 26th, and one, I think the court issued its decision on July 13th. So since the issuance of the injunction and the commencement of this litigation by the Attorney General, actually it's a litigation, but really what the Attorney General is doing is conducting a deeper and more detailed investigation. At the conclusion of the investigation, the Attorney General makes the determination as to whether to proceed further with a formal civil litigation or even criminal litigation against the Manhattan Club developers. So we're still in the investigative phase. The developer, Eichner, has taken two shots at trying to hobble the Attorney General's investigation. In the middle of last year or so, Eichner and his partners made a motion to, in essence, bring the Attorney General's investigation to a prompt conclusion. That was motion one. And motion two, in essence, to the effect, Mr. Eichner and his partners had been noticed by the Attorney General to conduct depositions, sworn depositions, and to give sworn deposition testimony. And they made what were called applications for protective orders, in essence, trying to cancel out and get out from under having to give deposition testimony. So those were two motions made, in essence, to hobble the Attorney General's investigation. The first one, as I said, to bring the investigation to an accelerated conclusion, asking the court to do so. Also, that first motion was to challenging the legal grounds, the technical legal grounds under which that court injunction was granted 2 years ago. And the second one was to protect against Eichner and his partners from having to give sworn testimony. So the first motion, that is to hobble the investigation, to cancel out the stay, to accelerate the whole, to accelerate the termination of the investigation, the court nixed that attempt. The court rejected Eichner's request. Was a rather extensive decision which was issued in that regard. And on the second motion, the one to protect against Eichner and his partners giving sworn testimony in the case, on July 13, the court issued a decision saying no, the Eichners and their partners have to give sworn testimony. So in both those cases, both those motions, the attempts by the Manhattan Club sponsors to hobble the Attorney General's investigation have been rejected by the court. The first motion, the one that was filed in May 26th, just this week, the Eichners filed, the sponsors filed a notice of appeal which starts the appellate process so that a higher level court gets the opportunity to review the lower court's decision. So Eichner is asking that a higher court overturn the lower court's decision. No notice of appeal has yet been filed for the second decision, the one about rejecting Eichner's attempt to cancel his sworn testimony. Those are the developments.
Doug, what do you see as the timelines, and will they again have continuing rights to appeal at each step of the way?
All right, so everybody has a right. That's just the way our judicial system is structured. Any party to a litigation, if they disagree with the lower court's ruling, has a right to appeal to a higher court and ask that higher court to overturn that lower court's ruling. And there are time frames that are involved in it. So the Manhattan Club sponsor has 6 months to perfect his appeal. That would be 6 months from the date he files his notice of appeal. That notice of appeal was filed just this week. So that's 6 months from this week to perfect his appeal. Perfecting the appeal means two things. One, putting together a legal memorandum containing all of the Manhattan Club sponsors' arguments, legal arguments, for the reasons that the decision should be overturned, and also putting together in book format what we call the record, all the evidence, all the proceedings, all the affidavits, all the documents, all in book format, and all that evidence is what the legal memorandum, the arguments are based on. And as I said, Eichner has 6 months to put that together and submit that. The Attorney General then has 30 days thereafter to respond and file their own legal brief, their own legal arguments. Sometimes these time frames are adjourned, so it could be that in this case these time frames do get adjourned for small periods of time. Once the case is fully briefed, both sides have submitted the legal memoranda, then a few months thereafter, 3, 4, 5 months perhaps thereafter, the case is argued before a panel of appellate judges. And at that, thereafter, it may take a couple of months for the panel to make up its mind. So if you take out your calculators and want to figure out how long that appeal is going to take from today, we're talking 6 months for to perfect the appeal, a month for the Attorney General to respond, that's 7 months, 3 to 4 months perhaps to argue the case, we're at 11 to 12 months, and then for the court to issue its decision, you have a couple of months thereafter. So there you have the approximate time frame for the ruling on an appeal. If the strategy of the Manhattan Club sponsor is to run the clock, then this is an excellent mechanism to do that.
And what is the advantage or disadvantage to running the clock in terms of owner interest?
Well, the alternative to not running the clock is the Manhattan Club sponsor is faced with an immediate confrontation with the Attorney General, so that there would be an immediate remedy. So running the clock simply defers and adjourns to that come-to-mama moment for the sponsor. And who knows what the future brings. And that's a strategy that defendants sometimes use in litigations.
Okay, so in this interim, is there always a potential for some form of a settlement?
There's always a potential for a settlement.
And how are you advising your clients as to what to do relative to, the end game and waiting it out? Are they being patient? Do you counsel them at all, or those decisions? And do they have an option if they decide they don't want to wait it out? What are their options?
Well, there aren't really a lot of options here for Manhattan Club owners, and that's part of the structural deficiency here. It's difficult to transfer a unit, difficult or next to impossible to transfer a unit. And so a lot of these Manhattan Club owners are faced with the dilemma that you had mentioned that Jeff had mentioned before about do we pay dues, do we not pay dues? Unfortunately, we're not close to the end game. I mean, we're still in the investigative stage. So we haven't even gotten to the point where the Attorney General formally makes the judgment that a fraud has occurred and commences an action for civil or criminal fraud based upon his conclusions. The Attorney General is not going to make that a judgment determination. At least this is what the the Attorney General said in open court, I believe, back in March, until they've had the opportunity to depose the Manhattan Club sponsors. So we got a long way to go. As to what I advise, it's really a judgment call as to whether to pay or not pay the dues. That's generally what I tell my clients. It's a question of their tolerance for risk. As Jeff was indicating, clients can't get rooms, and they're somewhat frustrated by having to pay thousands of dollars every year for an inability to receive the product that they've paid for. On the other hand, there are people who can't tolerate the potential risk of not paying a contractual obligation. So it's really a judgment call and based upon each individual's tolerance for risk.
Do they have an option of putting those maintenance fees in escrow?
Well, I mean, I suppose they can, but I'm not sure that accomplishes much, because if you put the maintenance fees in escrow, it still means non-payment. Those maintenance fees are not paid. So whatever the remedies are for non-payment of maintenance fees, and Jeff is correct, currently the injunction that was imposed 2 years ago prevents the foreclosure of these timeshare units. So that's not an available remedy to the Manhattan Club at the moment. But non-payment is non-payment. So either you keep them in your bank account, you put them in an escrow account. It doesn't accomplish it doesn't address the issue that the fees haven't been paid. And it's not only escrow fees. I mean, not only assessment fees, but real estate taxes as well that people aren't paying. Each unit, when at least in the Manhattan Club, when you buy a Manhattan Club unit, you're buying a piece of real estate, a tenancy in common interest in a real estate unit. So there are real estate taxes that are assessed. Some owners have elected to pay those taxes and not pay the assessments, and some are just not paying the taxes nor the assessments.
So when they're not paying, are those assessments going into default at the with the authority, the collection authority, or is someone paying those taxes?
That is an excellent question, and the answer is yes. I did a check of the public records, and of 6 or 7 clients of mine, I represent 28 of them, 6 or 7 clients of mine who had been paying their real estate taxes for their units, and when I checked the public records for those particular units, those taxes were in arrears. Now, mind you, when you own 1 week of a unit, you only own 1/52nd of that unit, so you need to rely on timely payment by the other 51 owners for a particular item to be fully paid. So those units, I checked, I think it was 6 out of 6 units that I checked the public records for, and those taxes were not up to date.
So is there a global perspective on that? Meaning if the taxes aren't being paid, is there a potential for default and some kind of, putting the property up for sale at an auction at some point because of non-payment of taxes? Is that a real possibility of happening in this case?
I can't tell. There are the city of New York, which is the jurisdiction which supervises the collection of real estate taxes. Taxes are payable to the city of New York. They have their own in-rem tax collection procedures. I'm not sure to what extent those procedures might be implemented in the case of such public interest as the Manhattan Club, where the Attorney General is so actively involved. I can't say. Do these become... There's a whole process for the collection of taxes called tax liens, where the City of New York doesn't actually foreclose and take units over for non-payment of taxes. They have a lien for the payment of taxes, and they sell those liens out to third-party investors. You know, it's too early to know what the remedy will be, and when that remedy will kick in for non-payment of taxes. When I did check, the taxes weren't significantly in arrears. I think they were 6 months or so in arrears each time I checked, and I haven't checked recently, so for all I know, maybe additional payments have been made in the last 6 months since I've last checked. So too early to tell.
Now let's turn to Jeff for a few minutes. And Jeff, explain why this is such a unique occurrence in the world of timesharing.
Well, that's a very loaded question, so I'll jump right on it. The timeshare industry has a long and interesting history of high-pressure sales tactics and making promises to owners that sometimes don't get fulfilled. And a case like the Manhattan Club is sort of like the worst nightmare of the timeshare industry on all fronts, all in one very high-profile city where everybody can look at it. So this case, no matter how it gets resolved, is an absolute black eye for the timeshare industry, in my opinion. It has gotten a fair amount of media attention from mainstream media as well as from timeshare folks that we know well. And as a result, it's followed by lots of people throughout the industry because they know that however the Manhattan Club case is resolved will impact public perception of what's going on at other timeshares. And I deal with real estate people frequently in different states. They know all about it. I deal with the industry lobbyists who were anxious that regulators will get more interested in timeshare issues if they see too many big headlines about supposed timeshare abuses. And you've got this very important development going on in the real world, which is that there are more and more timeshare owners who are getting older and are unable to use timeshares across the entire country. And they are running into a problem of how to sell their timeshare, and they're finding that many timeshares are worth maybe 10% what they bought for in the first place. So there are timeshare development resorts across the country where owners are now beginning to organize. And organize for various reasons. A lot of times they feel disenfranchised. They're upset about maintenance fees or reservations, some issues that are similar to Manhattan Club. The Manhattan Club also has a very active and vocal group of owners now as well, and they're fairly sophisticated. They write letters to the judge in this case regularly. And in fact, in the most recent court ruling earlier this week, Judge Rackauer mentioned that any delays in this case that are caused by more legal pleadings, any delays of the investigation harms the timeshare owners. Those are her words. And she references the fact that they have to continue paying maintenance fees while all the legal wrangling goes on. So bottom line, this case is watched throughout the country by people in the timeshare industry. It is watched by regulators in other states like Florida and California and Massachusetts, where there are heavy timeshare presences. And you've got some politics involved in this that makes it interesting as well. And the politics surrounds the career of the Attorney General of New York, Mr. Schneiderman, and what he wants to do with the soapbox that he's created with the timeshare industry. And it also involves a high-profile developer, Mr. Eichner, and his family and colleagues, who have a long track record of building giant buildings in big places. So you have sort of a clash of the titans going on politically, with hundreds, if not thousands, of Manhattan Club owners caught in the middle and frustrated, and other HOAs and timeshare resorts and management companies looking at this, hoping that it does not blow back on them.
Now, if any of our listeners would like to get in touch with you, Doug, to get more details about how you're working with the group of owners that you are working with, how do they go about doing that?
Well, I'm available by phone, 212-430-6040. I'm also available by email, Doug, D-O-U-G, at wassruss.com, Doug at wassruss.com. Or you can just simply Google my name, Douglas Wasser, and I should pop up on the first page of Google Returns.
And Jeff, you certainly have kept a significant number of owners abreast of what's going on through Red Week. So what's the best way to get hold of you?
Well, we have forums on Red Week that anybody can jump in on right now and participate in. They're on the Manhattan Club litigation as well as just the Manhattan Club itself. So if people want to get an idea of what owners are saying and thinking about, they can hop right on and join those forums. If they want to reach me, I'm really easy to reach at jeff@redweek.com. That's jeff@redweek.com, and I do respond to everybody that chases me down. And I have a running, probably like Doug, I have a running dialogue with owners who are really active in the Manhattan Club, and that tends to spill over into other timeshare resorts as well where there are similar owner issues. So jeff@redweek.com, be happy to communicate with anyone.
Well, thank you. Timesharing Today will be following up. We'll have future broadcasts on the situation there and as it continues to evolve. So thank you for keeping us abreast.
My pleasure, Shep, as always.
Jeff, thanks for having me.
And this concludes today's broadcast of Around the Industry. You know, at Timesharing Today, your opinions really do count. So if you'd like to comment on today's interview or suggest a topic for another broadcast, please email staff@tstoday.com. Until next time, happy timesharing.